Okay, everyone, we're going to actually go ahead and get started. For those of you that I don't know, my name is Jane Huckabee. I'm a clinical professor here and director of the International Human Rights Clinic. And it's my great privilege and also pleasure to introduce Steve Watt, who is a senior staff attorney of the Human Rights Program at the ACLU. And Steve is going to be giving a lecture today looking at legal challenges to the CIA torture program, addressing the role of psychologists in detention and interrogation. So really sort of brings up to speed on some of the very groundbreaking litigation that the ACLU has been leading in its efforts to gain accountability for violations in detention, interrogation, rendition, and torture. The event is part of our Human Rights Practitioner series here at the Law School, and is co-sponsored by the clinic, the Centre for International Comparative Law, a whole bunch of other co-sponsors, the Duke Human Rights Centre, the Kenyan Institute for Ethics, the Duke Human Rights Centre, the Franklin Humanities Institute, the International Law Society, and the Human Rights Law Society. So we're going to sort of follow our usual format, and we're going to have Steve give a presentation, and then open up to a moderated Q&A. We really encourage you to engage with his presentation and any questions you may have about these issues. And again, Steve, I'm absolutely thrilled to have you here at the Law School, and thank you for making the time in your extraordinary schedule to be here.
No, thanks very much, Jane, and thank you all for turning out this afternoon. So I would like this afternoon to speak about Salim versus Mitchell. Salim, this is actually Suleiman Abdallah Salim, one of our clients, and this is a lawsuit that we filed. But I'd like to speak about that lawsuit more broadly in the context of strategic litigation, and strategic litigation with a view to bringing accountability or promoting accountability for US involvement in torture post 9/11, and in particular accountability for US contractors to the United States government, and in particular health professionals contracted by the government. And so Salim versus Mitchell, just in broad brush, is a suit against two psychologists who were hired by the CIA to design, and not just to design, but to implement a torture program. They call it Detention and Interrogation program, but it's actually a torture program for all intents and purposes. So since around 2005-2007, there were media reports on the United States use of torture and the United States collaborating with contractors, and in particular health professionals, and two in particular, James Mitchell and Bruce Jessen, former members of the US military, both of them psychologists. And the reporting was that they had been involved in the torture of certain detainees in the custody of the United States government and facilities overseas. But it was the publication of the executive summary of the Senate report on the CIA's detention and interrogation program, which really shed light on the nature and the extent of the CIA's use of torture, and in particular the role played by not only James Mitchell and Bruce Jessen, but also other health professionals in the administration of the US, and in particular the CIA's torture program. From 2002, so shortly after the 9/11 attacks, through until the end of the program. It was ended by executive order President Obama in 2009. So that's what the executive, and it's an executive summary, it's a 600-page executive summary, heavily redacted in parts, but there are details of the CIA's torture program that the American public didn't know of before its release at the end of last year. Actually 2014, yeah. And what that provided was official confirmation of much of the media reporting on the torture program. And what what the executive summary gave us, what the information that was contained in there gave us, it actually gave us the opportunity to build at the ACLU, to build upon and amplify our existing torture accountability work through another lawsuit. And I say another lawsuit, so let me give you some context to the Salim versus Mitchell litigation. So from 2004 through until 2015, so just last year, there have been a series of lawsuits filed by the ACLU and other advocacy organizations challenging various aspects of the United States use of torture and cruel, inhuman and degrading treatment and punishment. And these challenged both the CIA program and also the US military program, and they were two distinct programs as we have since discovered. And the first lawsuit to be filed was a challenge to the CIA's Rendition and Detention program, and that was on behalf, this was in 2004, and that was on behalf of Meher Arar, who was a Canadian national transiting on his way through home to Canada through JFK Airport. He was detained in Communicado, and then he was sent to Syria, where he was tortured horribly for best part of a year before he was released back to Canada. And there was proceedings brought in Canada. There was also a lawsuit brought in the United States. So that was 2004. That was the first challenge to the CIA's torture program, which included Rendition. And that was brought against exclusively US officials, and the US immigration officials and the Attorney General. Then in 2005, the ACLU, we brought a suit against George Tenet and various aviation corporations used by the CIA to transport Khalid al-Masri, a German national, from Macedonia to a secret CIA-run prison in Afghanistan. This was in 2004. And then there was a subsequent suit, again brought by the ACLU, against a contractor to the CIA, Jeppesen Data Plan, which provided flight and logistical support services to the CIA to transport at least 5 men that we knew of, that we documented, to torture in overseas prisons, either by foreign governments or by the CIA itself. And then there's been a series of lawsuits brought against the US military, actors in the US military, on behalf of men who were tortured in the Abu Ghraib facility in Iraq, Afghani nationals who were tortured by the US military in Afghanistan, and then then a suit on behalf of Jose Padilla, who was tortured in military custody in South Carolina, and most recently a suit on behalf of a US national from New Jersey who was detained and tortured in Kenya by the FBI. So there was a whole slew of actors, US actors involved in torture, including US officials and contractors, and on behalf of many victims and survivors, both non-US nationals and US nationals. So that's the context to Salim versus Mitchell. All of those cases, all of them, apart from Salim versus Mitchell, which is still alive, it's only recently been filed, all of those cases were dismissed without any consideration on the merits. So they were dismissed on legal grounds. They were dismissed on either state secrecy grounds or a variation on that, an immunity grounds. And one would think that if we were litigating these cases to the merits, that if that was our only or primary aim, then really it's been an unmitigated disaster in terms of litigation and getting compensation and consideration of these cases, whether US actors tortured these individuals. It would have been, it would have been a disaster because we got no compensation, we didn't get any official acknowledgement. However, these cases were all part of a broader strategy, a broader accountability strategy, and that accountability was to address US torture, to hold to account US torturers, whether it's government actors or contractors, and accountability for victims and survivors. And the litigation was a key role in that broader advocacy strategy. And in addition to litigation, there was also, we did a lot of work, public education work through the media. We also did federal advocacy work. We also worked at the international level with various UN mechanisms and procedures to highlight these issues, all with a view to putting pressure on the US government, not just in the court, but outside the court, and also with working with the American public to try and change the discourse, to change the debate, and to try and get changes to laws, policies and practices, to get non-repetition. And in that respect, we would say there's been a qualified success. I think the debate has changed, and in some instances we are seeing changes in laws, policies and practices, most notably when Obama took office. Within 3 days, he signed 3 executive orders, one of which was to close Guantanamo. Guantanamo was still open, but the other was to prohibit absolutely the use of torture, cruel, inhuman or degrading treatment or punishment, and to essentially shut down the Rendition program by taking the CIA out of the detention and interrogation business altogether. And I think that's those changes are in large part due to the litigation, which was a vehicle to tell human stories, to give voice to the victims and survivors, with a view to changing the debate and to pushing changes in laws, policies and practices of the US government. And also we went after the contractors because I think it'll change their views in the future. I don't think you're going to see psychologists and health professionals getting as quickly into the bed with the government when there's detention and interrogation involved. I think we've raised the stakes for them through that litigation. So that's strategic litigation. It's using litigation as one mechanism or one tool to advance an issue, and in this case it's torture accountability for the torturers, as well as accountability for victims and survivors. And this notion of strategic litigation, this video which we're about to play, gives you some context to the Salim versus Mitchell litigation, which is it's kind of complicated because it's a story that we at the ACLU extracted from 600 pages of reporting, 600 plus pages. It was actually thousands of pages of government reporting and media reports, and to distill that down into a single narrative thread and to give a face to some of the victims and survivors so the American public can identify in a more concrete way with our push for accountability and why accountability is important. So after we play the video, it lasts about 7 minutes. I think after it you should get a real sense of what the litigation is about, and then what I propose to do, just quickly sum up 5-10 minutes. I'll just give you a rundown of the litigation itself and where we're at with that and what our next steps are in terms of accountability using this piece of litigation.
Tell me about your work.
I'm going to fishing.
Tell me, when you talk about fishing, you seem so happy.
Yeah, very happy. I remember now, flashback to fishing. I like to fishing. I like to walk the sea. I like so much, yeah.
It makes you relax?
Yeah, I'm relaxed. It makes no flashback. Every time I think to the flashback come, I can sleep, I can eat, I can smell. So if you're feeling, sleep. Flashback come anytime, yeah. So must you make you crazy. I'm so much pain. I don't understand anything. I have a headache, I want to vomit. I'm innocent. Why is it a bit like that? People do wrong.
Suleiman Abdallah is a citizen of Tanzania. He's a fisherman from Zanzibar. And he was captured and detained and interrogated in the CIA's torture program. He was innocent of any wrongdoing. He has had no dealings with Al-Qaeda, associations with Al-Qaeda. Their torture program destroyed him physically and destroyed him psychologically. And what history tells us is that if there isn't full accountability, if there isn't acknowledgement, apologies, and compensation paid to victims and survivors, then history repeats itself.
This is a story of professional opportunism, if there ever was one. Bruce Jessen and James Mitchell were two clinical psychologists who were responsible for originally creating, overseeing, and actually implementing the Bush administration's torture program as it existed in the CIA. Let's remember, here we are, 2001, after the World Trade Center, the United States is planning its global war on terror.
We will smoke them out of their holes, we will get them running, and we'll bring them to justice.
And from the highest levels of the administration, there is this idea that it's time to take the gloves off, that if we capture any of those operatives, we are going to do whatever's necessary to get them to talk.
From the very outset of the CIA's detention and interrogation program, the CIA were intent on using torture, coercion. Mitchell and Jessen provided them pseudoscientific veneer to the use of torture. They proposed a way of breaking down detainees. It was their belief, once you destroyed them psychologically, they would be compliant to the interrogator's demands for information. Their assessment formed the foundation of what became the CIA's torture program. And learned helplessness played a very important role there in their theory.
Learned helplessness is a concept developed by psychologist Martin Seligman to describe his experiments with dogs, where he would use certain electric shocks, certain terrible experiences, so severe, so continuous, and sometimes so arbitrary, that even without the electricity being implemented, even if the situation were safe, they had no capacity to assess that. They learned to be helpless.
For the first time, James Mitchell and Bruce Jessen were going to test that theory of learned helplessness on human beings. So this was human experimentation. It was their belief, once you destroyed them psychologically, they would be compliant to the interrogator's demands for information. And that's just junk science, because you speak to any psychologist, psychiatrist, or individuals that have dealt with survivors of torture, they'll tell you that if you torture somebody, they'll tell you anything that the interrogator wants them to hear.
Of all of the many prisoners who've been tortured, who I have interviewed, Suleiman's case was by far the worst.
Very, very bad as a prisoner. Cold, you say no, naked, so much music, high music, you can see. So darkness, really darkness, you can see any place, small room.
Suleiman was subjected to a range of different techniques. He talked about being subjected to water torture.
Plastic, so big plastic, the down, so cold, it's time to put me water. Put me water and beating the stomach.
Water was poured on his face. He was then rolled up in a plastic sheet.
Guy, he put me water. He was beating me so much. He told me, you see, man, but here rain not finished. But he told me, the rain not finished. After that, he took me to interview. The big light, took me in the face. After that, he took me again to the water. Same question, come to again to water. So every day like this. He said, every day is a punishment here. Every day to me a problem for me, better to die.
Their program resulted in pain and suffering for at least 119 men that we know of. They owe an acknowledgement to the victims and survivors whose lives they've destroyed, and they owe them compensation. And as a start point, the victims and survivors should have their day in court.
Long day, long years, you know.
The recovery process.
Yeah, but now a little bit I'm gonna better. Not like first. Maybe every day I'm gonna go better.
This is a reggae-loving, very relaxed, very kind-hearted fisherman. This is Suleiman. He loves music. One of the things that he does, despite having been tortured with music, he's managed to turn that around. And one of the things that he does to relax himself is listen to music, in particular reggae.
I come to listen Bob Marley. It's making me, I forget it's a flashback. If you intend now, in home, I like so much music, and forget about the prison. Now every day come better, every day come better.
So that is one of the plaintiff's stories, Suleiman. The lawsuit is also brought on behalf of one victim, Gul Rahman. He died under torture in CIA detention. That's recorded in the Senate report. And a third individual, Mohammed bin Saud, who's a Libyan national. He was living in exile in Pakistan, exiled from the Gaddafi regime, and he was rendered to the same facility as Suleiman a month after Suleiman, and detained there for 1 year in complete darkness, and subjected to much of the same torture techniques that were used on Suleiman, in some cases more extreme. And then he was transferred to a second CIA facility before he was rendered back to the persons who he had escaped from, the same persons he had escaped from in the 1990s, back to the Gaddafi government, where he was detained arbitrarily for 5 additional years. So these are 3 of the 119 I mentioned in the video, and those 119 are all named. They're listed in the Senate torture report, and I list at the back. So that's why the executive summary really gave us, the Senate's executive summary gave us a basis for this lawsuit. And I've met with Suleiman, and I've met with Mohammed, and Gul Rahman's nephew represents the estate of Gul Rahman, and his estate being his wife and 4 young daughters. And Gul Rahman's story is, for me, it's perhaps the saddest, because he, although in the Senate reports recorded that he was tortured to death, and actually tortured to death by a CIA operative who was trained by Bruce Jessup. That's all documented in the Senate report. And despite that acknowledgement of wrongdoing, of egregious wrongdoing, the family had never officially been notified of his death, and the body has never been returned to them for decent burial. And this lawsuit is a voice for these 3 victims and survivors, but also a voice for the other 116. And the Suleiman, Mohammed, and Gul Rahman's family were all adamant about that. Their wish in filing this lawsuit isn't compensation. It is a suit about compensation, and they should be compensated. But this suit, first and foremost, is about accountability, and that accountability for these victims and survivors. And I've, over the years, I've met with many of them, not just these 3 individuals, and all have been the same. They want some acknowledgement, and they want an apology, and they should get compensation. But compensation has never been at the forefront. And that, speaking to psychologists, actually psychologists who don't invent torture programs, they'll say that that's fairly typical amongst survivors of torture, is the acknowledgement is the most important part. And that's what this lawsuit, in part, gives to these 3 victims and survivors and the others who they represent. And I'll just tell you a story. When I met with Mohammed and I met with Suleiman, I went with a copy of the Senate report, and I went, their name is listed, and there's actually some of how they were tortured is actually noted in that report too. These guys can't read English well, but to see their name and to see how the Senate described what happened to them was really empowering for them. They both said that, and I was actually quite taken aback when they said that. They just, all I was doing was showing, you've told me your story, and now the US government in this official report confirms what you said. You were part of that program, it gives the dates, and here's some of the things they did. The full horrors of what they did to them are not in the report because it's an executive summary. But for them, it was really empowering. They wanted copies. They wanted copies of that just to show that there had been official acknowledgement. And the lawsuit itself and the process, that process of me sitting down opposite them and them telling me the story, for them is powerful in and of itself. It's empowering of victims and survivors just to have that official process of accounting. Even if we don't prevail in the courts, that process of sitting opposite a lawyer and then filing the suit for them is really powerful and empowering. And that's accountability. That's a degree of accountability on and of itself at the victim survival level. So accountability for Mitchell and Jessen. What the lawsuit provides is a single narrative, and I think, if you read it, a pretty compelling narrative based on official records of their responsibility for the torture program, for the design and its implementation, and the fact that they got $81 million as well is part of that story. They profited from torture, the torture profiteers. And what the complaint does, it distills down their responsibility, and it shows how they are responsible for violations of some of the most egregious human rights norms, the prohibition of torture, prohibition of cruel, inhuman, or degrading treatment or punishment. And as we were drafting the complaint, it became apparent to me that these guys actually didn't know what the hell they were doing. It was so smacked of Mengele Nazi doctors that I thought this is like experimentation, pure and simple. So as we were crafting the complaint, we said, yeah, this is non-consensual human experimentation. There's a prohibition. It's been prohibited since Nuremberg. So we have included a claim to that effect, but also because these harms occurred during time of armed conflict, be it international or non-international, these are war crimes. And we also have, in the lawsuit, we've sued Mitchell and Jessen for war crimes, as well as, so torture is a war crime, cruelty is a war crime, and the war crime equivalent of non-consensual human experimentation, medical and scientific experimentation on humans. So that is all in the complaint, and it's a single narrative thread. It's holding the torturers to account based on US law. So as I said, before I introduced the video, if adjudicating this case to the merits was our goal, we haven't yet achieved that. And there's a distinct likelihood, based on how the other cases that we filed, which are similar, I think there's fundamental differences between those past cases that were dismissed and this one, and that is mainly due to the Senate executive summary, that official confirmation. I think the government's going to have a much harder state secrecy argument, and they don't have the same immunity arguments because these guys are contractors. They're independent contractors to the CIA, so they don't come with the same entitlements to immunity as the government would, even in a case like this. We would argue that the government shouldn't be immune, but cases have all gone the other way. But there still hasn't been any definitive decision, judicial decision, on whether or not these guys that designed and implemented the CIA torture program can benefit from the government's same immunity. So I think the Salim versus Mitchell is a stronger case on the merits, but I think there's still very serious obstacles in our path to prevailing. And so if our sole goal going into this piece of strategic litigation was a decision on the merits, decision on the merits, even if we do prevail, is not going to come for like years down the line. And as I said, for these guys, it's not just the compensation that they're interested in, it's the acknowledgement of public accounting. It's going to be many, many years down the line. But that wasn't our sole goal. Our sole goal was beyond the courtroom. It was and still is to change the public debate, to change laws, to ensure non-repetition. And I think we're getting there, and I think it's in large part due to even these past failed cases and this one, is we're keeping a spotlight on the issue. We're keeping the issue alive. We're giving a human face to US policies and the debate around these policies, which I think is crucially important if we are going to succeed with torture accountability for the torturers and for the victims and survivors. And to give I've talked on behalf of victims and survivors and on behalf of Mohammed and Suleiman and say what they want, but it was really affirming for me that we got a note from Mohammed just after the litigation was filed. And this totally unsolicited or unprompted, we're not wanting gratitude for filing, but Mohammed sent us a note, and my colleague at work translated it for us. And I think that's a good place to end, because it shows what just the filing of a lawsuit means, and it goes to what strategic litigation is about, because it is about giving voice to victims and survivors. So what Mohammed said to us all at the ACLU, he said, "I find myself these days living historic moments of my life, and I cannot describe to you that wondrous feeling this litigation, this case, has provoked inside me. It feels to me as if I'm looking at a two-part picture. In one part, I see that dark and gruesome image created by Mitchell and his friends, who believed they could do whatever they please without anybody witnessing or hearing about their acts and making them accountable. In the other part, I see that rosy, hope-filled image created by the ACLU, who have dedicated themselves to lift the injustice and defend the oppressed. You have been indeed treating a deep wound and turning a gloomy and dark page. Thank you." So strategic litigation is beyond, it's looking beyond the courtroom. It's looking to who you're representing and what the litigation means for them. And it's looking at the bigger picture of accountability. And I think with persistence by the ACLU and others, and that's really a quality that you have to have, is persistence, creativity. I've personally been doing this for 12 years now, and and I haven't got past the motion to dismiss. So persistence is a real quality, and I think with that, and actions at the international level, domestically, and at the local level. There's some folks here from Stop Torture Now, North Carolina, Stop Torture Now, and they've been working on the ground, and I've been working on the ground with them since 2005. But it's the litigation, the strategic litigation, is bringing all that together, and it's pushing towards that one goal, which is torture accountability, and I think we will get there, as I say, over time. But I'm happy to take questions and on anything, on the plaintiffs or the legal issues, which are many. Happy to.
Just say who you are before you ask a question as well. Shira, do you want to come?
Yeah, sure, even though I stole Sarah's credo. I'm Shira, I'm a first year JD LLM student here. So I actually have two questions just about procedure. One is in regards to something like suing for a war crime. Does that fall under criminal code, and therefore are you suing for tort liability? I'm a little confused how that works. And the second question is what you're doing in the European courts.
Right. So the first point is the domestic one. So, and I meant to say that. This suit's brought under the Alien Tort Statute, which is an act of Congress, some of you may know of it, from 1789, which allows non-US citizens to sue for torts in violation of the law of nations. War crimes is a tort in violation of the law of nations. So it's an international tort. And the cause of action comes from federal common law, if we want to get into the weeds. And war crimes have long been recognized by the courts in this country as giving rise to a federal common law cause of action under the Alien Tort Statute. So that's what we're bringing under the ATS, but it's a federal common law cause of action for war crimes. But the definition is based on the international definition of what a war crime is. And you've got the European courts. So, our focus at the ACLU is very much on US accountability or US actors' accountability for torture and other violations of international law, but also of the Constitution, and that's the Constitution, and our constitutional remit is perhaps the vast bulk of our work. But what we do pursue is accountability of US actors in other venues. So we do at the UN level, but we wouldn't, there was a suit brought on behalf of El Masri, and there are other suits pending on behalf of persons who were rendered, detained, tortured by the United States, but in collaboration with European partners. And those European partners are countries that come under the jurisdiction of the European Court of Human Rights. So Khaled El Masri, so I mentioned, he was rendered from Macedonia. So there was a suit brought again after we had pursued our case in the US courts again on behalf of El Masri. Then we went to the European courts, and it was the Open Society Justice Initiative that took that case, but they collaborated very closely with us. So as an organization, ACLU, we wouldn't necessarily pursue, well, we couldn't pursue the US before the European Court of Human Rights because there's no jurisdiction, but we do go, we would contemplate going to other jurisdictions to sue the United States once we've exhausted our domestic remedies.
If you want to mention some of the things you've done in each American Commission.
Oh yeah, and that's so. Yeah. There's another human rights body that has jurisdiction over the United States, and it's actually based here in Washington D.C. It's called the Inter-American Commission on Human Rights, and that's 7 jurists from the Americas. There is a U.S. representative currently, and you can take cases once you've exhausted domestic remedies here to the Inter-American Commission, and we've taken cases on behalf of El Masri and also on behalf of the plaintiffs in the Jefferson lawsuit to the Inter-American Commission, and we also took a case on behalf of those men who we represented in federal court, Iraqi and Afghan nationals, to the Inter-American Commission against the United States once we'd exhausted domestic remedies there. The problem with the Inter-American Commission and the United States is that it's comity, and there's no enforcement mechanism. We can't make the United States respond. And in all these national security cases that I've been involved with and other advocates, the United States has simply not responded. So El Masri's case we filed in 2008, and it's sat. Despite the fact that the executive summary of the Senate report, which cites liberally from Office of the Inspector General report done into El Masri's rendition, unlawful rendition. They say, and the CIA, even in its response to the Senate report, acknowledged mistake that they screwed up big time. Yet the US government has dug its heels in with the commission and just is not accepting its jurisdiction. But that may change. I don't know. We thought it might change with the Obama administration, but it hasn't so far.
And on earlier cases, dealing, for example, with the rendition to justice, the rendition that preceded the CIA program, the US government did engage in the Interim Commission on those cases, right? Whilst saying that it wasn't binding and it was there as a matter of, of company, but there was some scope.
Yeah, the United States does engage with the Inter-American Commission on other cases,
yeah.
But on these national security cases so far, it has chosen not to. But as I say, that may change.
Hi, I'm Sarah. I'm doing my LLM in International Human Rights Law, and I'm a student practitioner in the Human Rights Law Clinic. So kind of touching upon what you were just saying, what goes into strategic litigation and the planning for it when you're up against a mammoth like the United States?
It's all about you're anticipating what to expect. I think you have to have a clear goal at the beginning. What's our long-term objective? So our long-term objective with this is torture accountability. How do we get there? Litigation is one tool. We know, and we use that litigation. We know going into it what the obstacles are. We want to see the memos that are written before we file one of these cases about what our claims are, but not just what our claims are, what we are expecting to meet down the road in terms of defenses. So you're suing the US government. We knew all about the state secrets defense before we filed these cases, and we were anticipating the state secrets defense. So what we went in was armed with the best legal arguments, but also we fought this case in the court of public opinion outside the court, using the vehicle of the litigation as a microphone for our piece. And what the litigation does, as I mentioned, it gives a human face. So it's not just some abstract legal principle. What you're doing by asserting the state secrets privilege is denying Suleiman Abdullah his day in court. Just his day in court, not even compensation. They're just denying him even the courthouse door. So there's all this thinking that goes into pre-litigation. So Salim litigation. The Senate report came out in December of 2014. We didn't file until October. So we filed it. We were actually ready to go earlier, but we decided that we're not going to file this lawsuit in the middle of summer where nobody's paying attention to. The issue of torture has kind of waned, and torture accountability has waned. But so what we had to do was maximize our opportunities in the media. So we didn't go in the middle of summer where people are at the beach. Those kinds of issues, and then. As I said, this video came out. We're going, how can we make this more real? How can people identify with what it is to be subjected to these, techniques that, in the Senate report, they're water dowsing, they're confinement box. What does that actually mean for somebody? And the way of doing that is, we can write the best legal prose ever, and we try and write clear legal prose, and I hope we achieve that in a complaint. But I think seeing it in a picture, I think, touches you in a way that black and white just can't get to. So that was the thinking behind that, was we need to humanize this. And so when we went out to Dubai when I went out to meet Suleiman in Dubai, I went out with my colleagues from the communications tower who did the video and everything. So we were going in with it, this is part and parcel of the broader objective, and it's the humanization part, which is key. So there's a lot, it's not just lawyers. So in other words, it's not just lawyers, it's communications folks, it's advocacy outreach people. We're very lucky at the ACLU that we're kind of multidisciplined, so we can actually bring those folks to the table. But it's really key, as you say, when you're coming up against the United States and you're coming up against, said since 2004, litigation which has really gone nowhere in the courts, that you really have to come armed with other tools.
Could we add on to that one thing? Would you mind to add a quick sidebar on how the state secrets immunity privilege has been invoked? I think there's a couple of people who may not be as familiar with it, and particularly what was really striking to me in the Jefferson case that you filed, also that the NYU clinic was a part of as well. That is the case against the Boeing subsidiary. Jefferson never actually answered the claim. The US government turned off and asserted state secrets. And so to kind of maybe talk about how that's been functioning a wee bit, and particularly how the official acknowledgement piece from the report may alter that information.
Yeah, because it's a good example, because so I was involved in the filing of El Masri and Jefferson. Both were dismissed in state secrets grounds. In El Masri, you would think that, because we sued George Tenet and we sued the aviation companies, so you think the government has an interest in there. State secrets invocation seems highly likely. Jefferson, we just sued Jefferson Data Plan, a wholly owned subsidiary of the Boeing Aerospace Company. We didn't sue the US government because we'd already sued them and they'd state secreted it. But what the government does, and what the courts have upheld, is that if the government, and it's the head of the agency whose interests are being affected, national security interests by and large are being affected, they can seek to intervene in any litigation, even if the United States isn't a party, to assert the state secrets privilege. It's a common law evidentiary privilege, but it's morphed somewhat over the years, and we feel partly responsible for that, as interpreted by the courts. It's morphed almost into an immunity doctrine. So what the head of the agency files a declaration setting out for the public why this case implements state secrets. But not only why it implicates state secrets, why the implication of those secrets means that the case should be dismissed from the very outset, without consideration of any evidence. So therefore, it's almost a justiciability doctrine as opposed to an evidentiary privilege, as it was originally conceived as by the Supreme Court. So what they say is, the head of the agency, so in our case it was the head of the CIA, would say that any further litigation of this case, even filing an answer to the complaint, would be prejudicial to US national security interests, so the case should be dismissed from the very outset, without consideration of any evidence. So it's not, our position is there is a state secrets privilege, but it's over discrete items of evidence, and should be asserted that way. So you can't file the state secrets privilege before the answer has been filed, before you know what evidence is going to be led. But in the Fourth Circuit in El Masri, they upheld the district court and basically said, it was an all-encompassing privilege, and they said that there's no balancing of the equities. It's plain and simple. If the government says so, so it is, and we dismiss the case. We actually, we were in the Ninth Circuit with Jefferson, and we actually had a favourable panel opinion. 3 judges ruled in our favour and said that, no, you can't assert it on that basis. It's an evidentiary privilege, so it has to be done on evidence by evidence basis, and remanded it back down to the district court to do that, to go through the evidence which the government said is privileged and that which can go forward on. But the full court, 6-5, we just lost by 1, found that no, it's all encompassing. It's a pretty awful decision. So it's basically, if the government says it is, then it is. However, we were given past record, we were expecting invocation of state secrets privilege in the Salim litigation. We were suing 2 psychologists, independent contractors to the CIA. So there's no government party, but clearly they were collaborating with the government, and there's clearly state secrets issues at stake. But what we did as part of our advocacy, and this is part of the strategic litigation, is that shortly after filing, we did a kind of full court press with our advocacy outreach. We bombarded Loretta Lynch with letters from our members and the like, saying, hold on, the executive summary to the Senate report changes the calculus here. you cannot come in and say the very subject matter of this case is a state secret. Too much is public, and too much officially confirmed public information, because that's the key. It's officially confirmed. Like a newspaper report won't cut it. And we accept that, but the Senate report is based on official confirmation. So a very subject matter state secrets implication, you know, that's, we basically said our position in a 2-page letter. And so far, they can intervene at any time, but so far they've stayed out. And it actually makes for more interesting litigation for us lawyers, is that we're not litigating state secrets, which it'd be really difficult if the government takes the same position. What we're litigating is political question. So the Mitchell's lawyers, and they're just a private firm of lawyers, the Mitchell and Jessen have gotten an indemnity from the US government of something like, I think it's like a $5 million indemnity to cover legal fees. So the government it's paying for it. Actually, you're paying for it, it's the taxpayers. But they've just got a private law firm, and they have filed substantive motion to dismiss, and they've said this is a political question. You know, really, it's the adjudication of torture. That is not a political question. I think courts make decisions on torture all the time, and whether particular conduct constitutes torture, and whether these guys were tortured. So that's their first volley, was political question that should be dismissed. The second is immunity. They're basically saying we're just doing what the CIA asked, and it was all approved by the CIA, so we should benefit from the same immunity, sovereign immunity, that the government should benefit. That isn't how the doctrine of derivative sovereign immunity, even if there is one, works. You have to show a history of that type of qualified immunity, and whether an individual, so psychologists who did what they did in that sort of context, did what they did, would benefit from immunity, and there is no history of that, not that we can find anyway. And then they've also done substantive motions to dismiss our Alien Tort Statute claims. They've argued that we haven't stated a claim for torture, basically saying because the OLC, the Office of Legal Counsel, said it wasn't torture, then it's not torture. And that, you know, John, yeah, that's what they're arguing. So they basically said the John Yoo memo said it wasn't torture, so it can't be torture because we didn't intend to torture these guys. That's, you know, that doesn't even pass the laugh test. I mean, I think in our opposition it takes up half a page. And then they've also argued that our non-consensual human experimentation claim isn't cognizable under the Alien Tort Statute. Basically, international law doesn't recognize this prohibition. That flies in the face of Second Circuit in a case from 2011. It's fairly recent. Basically did an exhaustive survey of relevant law and found that non-consensual human experimentation, in that case pharmaceutical testing, does violate a norm of international law that can be brought under the ATS. So I think we've got good arguments to counter them. We just filed our brief. Their reply is due on Thursday, actually. And then we've got argument before the court in Spokane. We filed in Spokane because the torture program was created by them in Spokane. It's the Fairchild Air Force Base is there, and both of them were employed, and that's actually where they came up with the idea for their torture program, was in Spokane, Washington, and one of them, Jessen, is actually domiciled there. The other's in Florida.
So we've got a few minutes left. I know a number of hands, so why don't we take a few questions and ask you.
Hi, I'm Eleni Bax. I am a 2L student, and I'm also in the International Human Rights Movement. I was wondering if you could speak a bit more about how you go about choosing your named plaintiffs. Is it just who is wanting to do that? And then also, how do you then translate the accountability and responsibility, that feeling that you said that they got when they looked at the Senate report, to the individuals who are not named?
Yeah. Anyone else? No. Sarah, great. Yep.
Got loads of questions. So another one is, so compensation has always been a kind of controversial topic in human rights litigation, and how do you go about dealing with that, and how do you discuss it with your clients, and also how do you manage their expectations in terms of the litigation not panning out the way that they'd like to?
Yeah, that's all good questions, and they're kind of related. So choose it. You know, there's 119 individuals named in the Senate report, listed in the back. We don't know where all those 119 are actually. I don't think anyone's documented that yet.
No.
I think there's a large number. Some of them are in Guantanamo.
Yeah.
And then, you know, like I knew of quite a number of them from over the years in my work on Guantanamo and torture-related issues in the United States, and my contacts with advocates, including Clara, Jane knows Claire as well. She's an investigator based out of London. Claire and I go back like 10 years, and it's those contacts. It was identifying who we knew first. And then actually identifying stories that would resonate. You know, it's sad, but even in this day and age, if we can get like an innocent or like a good torture plaintiff, you know, it doesn't have too much of a like baggage background. I hate even suggesting that, because torture is wrong whoever the person is you're torturing. But for this kind of litigation, there has to be, you know, you have to serve up a plaintiff, and that would be acceptable to a large swath of like American public and sort of the international community, and that's still in this day and age important to do. And actually, a lot of these guys in there had those types of stories, so that wasn't that difficult. But it was actually identifying that. Mohammed had actually been interviewed by. And it's also for them as well, because you don't want like Fox News or this kind of media going after them. So it's important that they're as beyond reproach, if you want that. I suppose I hate doing that, but that's what you have to do.